Tomorrow marks 1 year since the U.S. Supreme Court's historic decision to overturn Roe v. Wade and send the question of abortion access back to the states. That set South Carolina on the trajectory to where it'll be next Tuesday when the state Supreme Court will hear arguments for the second time in 8 months on the legality of a 6-week abortion ban. State House reporter Mary Green explains why Republican lawmakers believe they'll see a different outcome this time from the law that was struck down just 5 months ago.
We again, as a body and legislature, believe that the bill is constitutional and will be declared so by the Supreme Court.
When the Supreme Court struck down the former 6-week abortion ban in a 3-2 vote, the 5 justices took the less common step of issuing 5 separate opinions. In the months since, the legislature passed a new 6-week abortion bill that the governor signed in May, and that was blocked from being enforced a day later. Republican lawmakers made changes to the former law in writing the new one, but they say they tailored it to address concerns justices raised in their written opinions, especially those from Justice John Cannon Few, considered something of the swing vote in that 3-2 decision.
We tried very hard to pay attention to what they wrote and then to respond to it.
For example, Justice Few took issue with the part of the former law that recognized the importance of informed choice about whether to continue a pregnancy. Attorneys challenging the law had argued data and research show many women don't know they're pregnant at 6 weeks when getting an abortion would become illegal. Few wrote that informed choice is a private choice, as the court ruled the former ban violated the constitutional right to privacy. Months later, lawmakers took this informed choice language out of the legislation and did not include it in the new bill, one of a number of language and definitional changes they made to it.
I feel good about where we are. I think we made enough adjustments to the original law to respond to especially Justice Few's concerns that I'm hopeful that we can win him over, that we've addressed those things.
Justice Few wrote that while he does not believe the South Carolina Constitution protects an explicit right to abortion, the old law was an unreasonable intrusion into a pregnant woman's right to privacy, a right that is protected in the state constitution.
The substance of it is still exactly the same. The 6-week ban is still the 6-week ban.
Attorneys for South Carolina abortion providers argue that's why this new law should be found unconstitutional as well. Both the new law and the old one banned most abortions after around 6 weeks, with limited exceptions to save the mother's life in cases involving fatal fetal anomalies and for sexual assault victims, though the time frame in which they are allowed to get an abortion has been cut down.
The previous bill, which was already ruled unconstitutional, the exceptions had a 20-week time limit, and that has been reduced in the new bill to 12 weeks. So it is a further, more egregious violation of constitutional rights.
It's important to note the Supreme Court itself has also undergone a major change. The justice who wrote the majority opinion in the January ruling and who had been the only woman on the bench retired, and the Republican-dominated legislature elected her male replacement earlier this year, forming an all-male bench. But Republican leaders at the State House are adamant their confidence in this new law is based on changes they made to the language and not the change to the court itself. Reporting in Columbia, I'm Mary Green.
The new law has other changes from the former one that might not factor into the court's decision, but could be significant if the legislation is upheld. For example, it requires biological fathers pay child support dating back to the date of conception and repeals a decades-old part of state code that could criminalize women who self-manage abortions.